Well, the breaking news on your screen in the last few moments, the organisation Afriforum now going to the Gauteng High Court, filing an application to have the Expropriation Act declared unconstitutional. Of course, we know that the Trump administration might well bring this up during the conversation with President Ramaphosa this afternoon. The head of public relations for Afriforum is Ernst van Zyl. He joins us now. Ernst, good morning. I appreciate your time on Newzroom Afrika, Channel 405. On what basis are you going to court? On what basis are you asking a judge to find the Expropriation Act unconstitutional?
Good morning, Stephen. So Afriforum's argument is actually quite simple and straightforward. One of the main areas of concern is Section 12(3) of the Act, which provides for expropriation of property with nil compensation. Now, there's been a lot of debates around nil compensation, no compensation. Are these the same things? Well, in Afriforum's mind, nil compensation, and in Afriforum's argument, no compensation means no compensation. And the Deputy President, Paul Mashatile, has also confirmed that the ANC understands nil compensation to mean no compensation. So this section of the Act opens the real possibility of abuse of power by the government, especially through that the expropriation power is given not only to national government, but also to mismanaged local authorities are also given the power to expropriate without compensation. So that's one segment of our court challenge. There's many other segments of the law that Afriforum sees as problematic and as unconstitutional. For example, the fact that the Act allows a property owner to be deprived of their property while the matter of expropriation is fought over in court. And that's a process that can take years upon years. I think the first court date you'll get if you start your court process in 2025 in the High Court will be 2028. So that's just a little bit of a foretaste of what that fight is going to be like. Right. And all the while you are deprived of your property.
So, I mean, as I understand it, I mean, you're correct, it does use the phrase nil compensation. It's under very specific circumstances, though. It's, in fact, usually if the owner can't be traced. I mean, that's the main thing. And then we do know, for example, in Joburg, there are abandoned properties. No one knows who the owner is. They've disappeared years ago. The net result of that is that no one can do anything with those buildings. I mean, I'm not arguing for government here, but if I were, I would say the only reason we have that in is because we need to be able to do something with this very big problem of buildings which have been abandoned. And isn't that a legitimate purpose? I mean, surely you would agree something needs to be done.
Well, Stephen, I wish that the parameters that are given or set out by the bill was as specific, but Section 12 that deals with the nil compensation clause, that section, the intro to that section says, here are some of the scenarios that will be under which nil compensation can be paid, but this list includes but is not limited to, which means it is an open list, that this power is not limited at all. It's actually quite broad. So some of the examples that you mentioned there, those are mentioned in the bill as examples, but it's not an exhaustive list. It's not a limited list. It is a list that is headed by the phrase including but not limited to. That's very dangerous, giving the government that wide-ranging power specifically for nil compensation for confiscating property.
We haven't had any cases yet, and I mean, I realize that in terms of strategy, there are different ways to do this. For you as Afriforum, you could wait for a case and basically sort of join the case or be a part of that case, or wait to see how it all plays out and challenge each step, and there'll be a large number of steps. So I'm interested in your tactics here. You've decided to go to court now before any cases. I can understand why you would do that too. Is there a specific reason you're going to court now?
Well, there's a multifaceted strategy from Afriforum's side. I mean, this court challenge, challenging the constitutionality of the Act, is simply one of the avenues that we're using to challenge this threat to private property rights in South Africa. One of the other avenues, you're 100% correct, would be if property is then targeted for expropriation without compensation, is then to take on that case as to set a precedent in regards to a bulwark to defend private property rights in South Africa. So I think when it comes to Afriforum strategy, there's many facets. One of them is this constitutionality challenge, but then also we are at the ready for the first case where the government tries to expropriate someone's property without compensation. we will definitely be monitoring for it and keeping our radar sharp for the eventuality if that happens.
So there was a previous expropriation law, Ernst, as you'll remember. I think it went
Correct.
back to the 1970s. And the big difference, I mean, there are quite a few big differences, in fact, but the difference that you would refer to, I'm sure, is that Expropriation Act did not refer to nil compensation or no compensation in any way. There was always compensation. But the law as a whole, the new law, according to the legal interpretations I've seen, including from the Agricultural Business Chamber, so representing farmers, it would actually seem that this bill, the current law, gives more rights to landowners than the previous law. So I hear you on the issue of nil compensation, and the Constitution is quite clear about that, so we'll see what the judges say, but you may find yourself on very strong ground. But as a whole, landowners may actually be better protected under this law than the previous law, and you might find you have unintended consequences, is my concern.
Well, the thing is that in regards to unintended consequences, I think there's still a larger debate regarding which parts of the bill can remain and which not. But the part that enables expropriation without compensation is such a serious threat to private property rights that it kind of nullifies any other benefits that might come with some of the reforms that are added into this bill. It's an unnecessary, unconstitutional and unnecessary part that has been added, and it grants the government a power that it should not have, a power to expropriate property without compensation, not just under very limited circumstances, but under very broad circumstances, as broad as an idea like the public interest. If the government says, well, land reform is in the public interest, therefore we can expropriate this property without compensation, well, that gives them a very broad spectrum of abuses that they can possibly do with the power that this bill grants them. So yes, there's a lot of other facets to this bill where there has been changes made to the previous expropriation bill, as you point out. But this particular segment that enables expropriation without compensation is much, much more dangerous than any other small reform that has been added. That section alone, section 12, that enables nil compensation, is the main threat that needs to be addressed first. Then we can, after that is addressed, after that risk to private property rights is no longer a risk, then we can talk about the rest of the bill. I think there's still a lot of room for this bill to be amended so that it brings about positive change without threatening private property rights as it currently does in its current form.